right. You all have filed a series of motions. State, you filed first, so which ones you want heard in what order? Go.
I have them in order. I can just announce it and we can start if that's okay.
That's fine.
First one is the state's motion in limine regarding arrest of accessories. That's not the exact title, but I think Your Honor knows what I'm referring to. As will be the case, unless Your Honor tells us otherwise, I don't have any additional argument unless Your Honor has questions about what I'm seeking to exclude and why. This motion in particular came from the trial testimony from the first trial, the questions that were asked. We don't believe that the mere fact of the arrest is relevant, particularly not any mental illness that any witnesses have, or whether or not the Office of the State Attorney for the Ninth Circuit filed charges. And we asked all those questions beforehand.
Response?
Part of this case is
Mr. Linneman, you're still required to wear a mask. All right. Okay, good.
So, an issue that is important is that in this case is that my client made several statements on wiretap related to the issue of police. At least one.
Okay.
Also in the discussion, he talked about why the reason is for him coming back and turning himself in. The state has suggested already through Facebook posting, and I anticipate they'll do otherwise, that my client had a long-term desire to kill a police officer. My client ultimately gives himself up. He waves a flag, he throws himself out, and he does that because he wants to give up, and he doesn't feel immediately threatened, and more importantly, he wants to provide the reward to Ms. Dixon's father, who will give it to the children. He says that on the wiretap. He also says that he comes back for his girlfriend, his ex-girlfriend, who was arrested and placed in jail, also indicated trial, was arrested and placed in jail. So all of that is tied in to the issue of his surrender, his reason to surrender. And by them raising the issue that he's a cold-blooded cop killer, this is evidence that disputes it, the record. Because if that was the case...
How does the arrest of James Slaughter, Ms. Smith Loyd, or any other suspects, other than Mr. Loyd, obviously, but how does the arrest of those folks have anything to do with Mr. Loyd's motivation for... What you just said is the state's offering it as evidence of motivation to kill a police officer?
What they're offering it for, Judge, you'll see when they present a Facebook post, they're trying to attempt to...
I've read the Facebook post, but that's not what we're arguing about right now. It's the arrest.
It's related to rebuttal to that, to be able to rebut that issue, knowing that if this court lets in any evidence outside of the event that occurred at Walmart, that Mr. Loyd had a propensity or desire or whatever to kill police officers, that we need to be able to rebut that. So he comes from a safe place.
So tell me how the arrest of these folks who eventually were released and weren't charged is related to what you are just saying.
Just the arrest of his ex-girlfriend, not the other two.
Which one is it?
Janice.
Who?
And his niece, he says, Lakencia. So there's two, Lakencia.
Lakencia Smith and who? I have James Slaughter. That's not his niece, right?
No.
Okay. So that has to do with...
It has to do with his state of mind of wanting to surrender. It refutes the idea that he has this long-term goal of killing police officers because he puts whatever freedom he has, and he had freedom because he wasn't even in Orlando at the time, he puts that aside to come in and give himself up to help them out. Because they were arrested basically to draw him out.
State, what's your response, please?
There's no logical tie between those two things. There's just not. I'm not making the connection between Mr. Lloyd's desire, assuming it's true, to help out family members by turning himself in, and whether or not he has a desire to inflict harm on law enforcement. There's no tie. What I suspect would be to try to paint law enforcement as if they had done something improper by making an arrest of individuals associated with Mr. Lloyd, particularly any individuals who are alleged to have had mental illness. So absent a tie to relevancy in some way, we believe it's inadmissible.
Okay, here's what I'm going to do. I'm excluding it for now, but if you can tie it up during the trial, I'll revisit my ruling, but it's excluded at the moment. All right, next, Mr. Williams, what's up next? So the motion in limine regarding arrest for accessories is granted without prejudice to raise it if a door is open during trial.
So you're aware, Ms. Lloyd has told me just now that he wants to start.
Okay, well, we're going to do the motions first because it's 3:30. It's been a really long day and we'll get to it later. Okay, go ahead.
It's part of your motion, so you know.
Okay, I'll get to it in a little bit. Go ahead, Mr. Williams.
The second motion is the state's motion in limine to exclude self-serving hearsay as a conduit, specifically after Dr. Jeffrey Toomer, who is the defense expert on this sanity witness.
Okay, what is it exactly that you're trying to exclude? Because I read the motion, but it doesn't give me any statements. It doesn't tell me anything. So can you tell me exactly what you're trying to exclude?
No, because I don't know exactly what Dr. Toomer is going to say.
Well, that makes it hard for me to rule.
I understand. What I don't want to happen is for Dr. Toomer to get up there and start testifying that Mr. Lloyd told me blah, 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 blah. And I know Your Honor may understand the rules of evidence, but I've been in courtrooms where that has happened and it didn't seem to be a problem. I read defense counsel's response. We agree that if there is evidence that meets an exception or is admissible, Dr. Toomer should be able to discuss it. But the mere fact that something was told to Dr. Toomer, and specifically Mr. Lloyd's statements to Dr. Toomer over the course of interviews, are not admissible and cannot be discussed whenever Dr. Toomer is discussing his testimony. That's the reason for the motion.
All right, so I actually don't need to hear from you on this one. Here's what I'm going to do. Since I have no idea what statements we're talking about, and I'm kind of ruling in a vacuum, I mean, everybody knows what the rules are about conduit, using experts as conduits. So to avoid a huge problem in front of the jury, you're going to proffer Dr. Toomer's testimony. You're going to object along the way. I'm going to rule on it, and then you can call him in front of the jury so that we're all clear on what he can and can't say. Okay? All right, thank you. Next.
The state's notice of intent to use exhibits in reference insanity and open.
Now that one I actually had the time to read. Mr. Lenneman, what's your response? I read it. It's pretty. Okay. Well, do you want to add something to it?
Yeah, only that, Judge, there's no question that they're trying to be hard. I don't disagree with the stuff like the video, pictures, photographs, stuff that is coming into the case.
Right.
I don't have a problem with that. I have no objection to them using those, as long as they're saying they're using it in good places. But in terms of the issue of attacking my case, that's the only thing that's confusing. Subtly or otherwise, that is prohibited. Argument is not allowed in open statement.
Are you saying that they can't get up and say, our expert, whoever, there's too many doctors, I can't remember who's testifying to what, but Dr. X is going to testify that he examined Mr. Lloyd and Mr. Lloyd was not insane at the time of this incident? Are you saying they can't say that?
I'm not saying they can't say that. The problem with that, Judge, is it has to be rebuttal witness on the issue of insanity. And both of these doctors, especially the one I just took, is throwing out all kinds of things inaccurately about priors and past behavior and all kinds of stuff. So I don't disagree that they could argue in good faith the general concepts, but they can't relate it to Dr. Toomer or anything that he said, because that's argument.
They can testify, I'm sorry. Good Lord. They can, in opening, just like you can, state to a jury what they believe in good faith their experts are going to say. They can't say, you know, Mr. Loyd is clearly not insane, and our experts are going to testify that he's not. They can't say the first part of that is argument. Our experts are going to testify as follows is standard opening, which you can do also. I'm assuming you're going to get up and say, my experts are, so everybody just stay inside the rules.
My understanding of the motion that you filed is much more expansive.
Mr. Williams, are you planning on going beyond what you expect the testimony to be on the issue of insanity?
No, Your Honor, anything beyond that would be argument, which is impermissible.
Okay, everybody stay inside the rules. So you can use your exhibits. Well, again, as long as you have a good faith basis for what you believe your experts are going to testify, same for you, as long as you have a good faith basis, all right? So I guess the motion is,
It was actually, I styled it notice of intent.
oh, okay.
To give Your Honor a heads up, defense counsel. So I don't know that you actually need to do that.
I don't think I need to rule on this, just everybody stay inside the rules. All right, next.
The fourth motion is the state's motion to admit baseball players.
Let's do some of the easier ones and then we'll get, or unless you guys have stipulated on this one.
I don't believe the stipulation.
All right, let's skip this one and go on to, I'm going to listen to it, but I want to do as many as I can quickly. Go ahead.
Mr. Buxman has a couple of state motions, and then it's just whatever Mr. Blanton's motions are, and we're prepared to go on those.
Okay.
Both of mine are penalty-based motions. I don't know if you want to hear them at this point or not.
Which were your two?
I filed them. We had a hearing on the state's motion to prevent mention of the ACE study, which was branded. The defense has filed a motion to reconsider that.
I was told that that motion was filed. I haven't looked at it. I'll take a look at it in chambers and see if I need a hearing on it or not.
And the other motion that I filed dealt with Dr. Wu's PowerPoints and the use of various slides and citations and references and things.
Well, here's what I need. I need to know specifically did you list in the motion specifically which of those you're objecting to?
I did, Your Honor. I laid out in the motion and attached a copy of the PowerPoint itself with the corresponding slide numbers.
That's a different one. Hold on. I have a whole pile here.
Paragraph 3 lays out the specific slides and the specific objections to each of the slides. I did realize I missed one slide.
All right, so here's the ones that I have marked as you're objecting to. So tell me if there's any others. And I'm going to refer to them as the page numbers that are on the bottom of these slides attached to the motion. I have page 32, page 33, page 34, and then I have page 48, 49, 50, and 51. And lastly, I have page 52. Did I miss any?
Slide 14.
So is it page 14?
Yes, I'm sorry.
Okay. I didn't know if the slides corresponded to the pages, so, all right.
They did.
Page 14 you're objecting to?
Yes.
Okay.
Regarding-
Or slide 14, okay.
18, 21,
Hold on. I gotta mark these, otherwise I won't be able to keep track. So 14,
14,
18,
18, 21, 25,
21, 25. Okay.
16,
16 I already marked, I think. No, go ahead.
And I think I mentioned 18. I think
You did.
that's all of them. I think they're all listed under paragraph 3 of my motion and broken down into collections of, under certain topics of why they're inadmissible.
So it's all the ones I mentioned plus the ones you mentioned today.
I believe so, Your Honor, yes.
Okay. And Mr. Linneman, you said you're not ready for this one today?
While we're picking the jury, we received the definition of our last two experts that were taken back to the definitions of minus pages.
Mm-hmm.
I hadn't had a chance to do that yet. We want to hear about this.
Okay.
I did forget one slide. The end of slides, or the end of page 17 contains a reference, which I didn't include in my motion. I just noticed it earlier. It contains a reference to the arrest and the losing the vision of his left eye. That's for a different reason.
Okay.
Thank you, Your Honor.
All right, so I'll put this one aside. You'll need to get this done before penalty phase. All right, what's the next one you all have? Is that it for the state? Before, putting aside the Facebook motion for a moment. All right, what happened, what's going on with the mutiny motion, as I call it?
What motion, Judge?
The mutiny motion, the aggravator of prior violent felony, federal conviction.
So we have an expert who was his public defender.
When's that going to happen? Because this has been going on for a month.
He wasn't available today. He would have been available sometime during the week. He had court issues today all day. So I don't think his testimony is going to be super long. I think we probably can do it all in an hour. Easy.
Okay, because we need to get, this motion's been floating around now for over a month. It's actually been filed for a while, but it's been, coming up for a month, so it needs to get heard. You need to set that one and the Dr. Wu motion for a hearing, and then folks either have witnesses or they don't, but I'll talk to Trina to give you some times for these. Okay,
I
next.
think that any witnesses would be appearing by Zoom anyway.
That's fine, yeah.
Thank you, Your Honor.
He's been deposed?
Yes.
Okay. All right. So, is that it for the state's motions?
It is, yes, Your Honor.
So, I'm going to call up defense motions for rebuttal argument. You have any additional argument to make on that one, Mr. Lenneman? Oh, it's yours. I'm sorry, Mr. Marrero.
No, that's okay. As far as that argument, the most that occurred to me is asked about the alternate argument that if the court rejects this one, that we get certified on the issue of intent. And I think that would be good. In terms of the closing argument, the state would go first, we would go next, state would get rebuttal, and we would get sir rebuttal only on the issue of insanity because we bear the burden. I think that's a fair policy.
State.
Compromise has to be based in law, and it's not. He has to hope for my motion.
Yeah, I didn't see any legal, there's no legal basis for it, motion denied. Okay, and then I have the requested jury instruction on the definition of clear and convincing evidence. Who's arguing that one?
I have no issue.
State?
We object, and more specifically, particularly to eliminating the language that they seek to eliminate from the current standing instruction.
Yeah, the insanity instruction has the definition of clear and convincing evidence. I'm going to deny the requested instruction. And defendant's request for judicial notice or in limine to instruct an expert. Who's arguing that one? Okay.
So essentially what happens is Dr. Gamache, who knows the law better than most lawyers, So he took a position in the deposition which is inconsistent with the law. The law being that an expert on insanity would reach the ultimate decision saying that the person is insane.
Okay, I'm listening.
After he goes through the process. Dr. Gamache does not agree with that. His opinion of the law is, as he says it about 15 times.
What exactly is it that he says?
He says that he's not the one, he's not the trier of fact who makes the final decision. So he would never give his ultimate opinion on the issue, that he would reference the insanity provision and go through that. He would never give an ultimate opinion, nor does he believe that anybody with the trier of fact is allowed to do that.
State response.
I think what he would say is that it is the ultimate decision of the trier of fact to make that, to reach that conclusion, which I believe is an accurate statement of the law. I won't ask him that. He said it multiple times because Mr. Linneman asked him multiple times and it was back and forth. So my intention is to just have Dr. Gamache stay away from it, state his opinion, and it's not going to be an issue. But even though I don't think his opinion is legally incorrect.
Well, the ultimate decision belongs to the jury as to whether or not Mr. Loyd was insane at the time of the offense. That's a jury call.
Yes, Your Honor.
Just stay off this, is what you're planning on doing?
It is, Judge.
Okay. All right. What other defense motions are there?
Focuses the Wheeler issue, which focuses on penalties.
When did she file? You have got to stop filing these late motions, all right? You're outside the time for filing motions. So what motion are you talking about?
It wasn't late, Judge. It was last week's, while we're in the middle of
Oh,
litigation.
that one I'll deal with in chambers. Okay. You talking about the use of force motion?
Yes.
That one I'll deal with in chambers.
You have some additional arguments.
Go ahead.
Number one, that this evidence is usable in the docket for the reconstruction from the death penalty, defendant's mitigation. It's the same type of evidence that was committed in the Wheeler, that as a matter of law, if someone lost their left eye before this trial began, the judge would have to agree that it's impermissible. And that's exactly what happened.
I'm going to deal with this one in chambers. All I'm going to say is I think there's been a misunderstanding of what, when you're talking about use of force in here, you can always have someone testify that Mr. Loyd lost his eye, but he doesn't have an eye. I'm going to issue a ruling. You'll get something from me. Okay. Before penalty phase. All right. Anything else? Okay. Facebook account. Go ahead, Ms. Murray. I thought you guys told me you stipulated to something about this.
I believe the stipulation to the authentication of the Facebook records themselves,
Okay.
not to the admissibility of the content.
So to be very clear, no one is saying this is not Mr. Loyd's Facebook account and he's not the person posting this, correct?
That is my understanding.
Mr. Lenneman, is that the understanding? This is, you all are stipulating that these posts that are offered, they're attached as Exhibit A to the motion, regardless of whether they're in or out, but you all are stipulating that this is Mr. Loyd's Facebook account and he posted this?
Yes.
Okay.
Well, he posted the one that identified him.
Right. Yeah. I mean, the responses are clearly not him, but I'm just saying. All right. So so much for the stipulation. Mr. Williams, what are you all offering this for?
Mr. Lloyd's intent to kill Lieutenant
Okay. These are posts from 2014, 2016. The incident occurred in 2017. So what's your argument?
My argument is to cite the court to the two cases that are in motion, Buchanan and McVeigh, one of which I think is McVeigh, where the Supreme Court admitted statements, incidents made and committed by the defendant 2 years prior to the actual murder. There are a number of posts that we're seeking admission to. The oldest is 2 years prior to the murder, because I believe it was late summer of 2014 versus January of 2017. The more recent ones are within a 6-month time frame of Mr. Loyd committing the murder. We have to prove intent, commit murder, and motive, and that's what both the Buchanan and McVeigh statements go to. I fail to see how Mr. Loyd's statements about murdering police officers and encouraging others to do so would not be relevant in a case where he murdered a police officer, even the ones that are 2 years old. And I understand the court's remoteness concern, which is why I made sure to cite the case that I found that had that time frame. I think at a minimum, the statements that are within a tighter time frame, 6 months to a year, are clearly admissible. And I think, frankly, Your Honor, that all of them would be admissible should Mr. Loyd raise a self-defense claim in any way whatsoever. He was acting to defend himself, because this would obviously rebut any claim that he would make that he was defending himself from the time.
Thank you. Response?
Yeah, Judge, I agree with you in terms of remoteness. I think that the state is misinterpreting what
Mr. Lemon,
he's saying.
you need to stand. I can't hear
What
you.
he's saying in those posts, that I think is distinguishable from the court's decision that we cite. And I think clearly under 403 that we I mean, he labeled them, one with corrections, one with kill, and the other one was...
What are you talking about? I'm not following. He labeled what? Who labeled
He
what?
labeled them, Mr. Williams.
Oh, okay.
He labeled them, one with kill, one with corrections, and we're trying to look at the other one was admit records, guilt.
I can probably clarify that.
That would be helpful. Yeah.
So there were, as I referenced in the motion, tens of thousands of pages of Facebook records. So I picked out the specific posts that we were going to use, and I sent them to Mr. Lemon.
Okay.
You only have 2 of the 3 sets, because the third set is only relevant to the county.
Okay.
And that deals with corrections officers in regards to the meeting Mr. Oxman's argument.
Okay.
That's why you don't know, because you don't have them in front of you.
That's why I couldn't follow this. I'm thinking, I don't have all this. Yeah. Okay.
There are 2 sets of Facebook posts, however, that are part of my motion, and I delineated between the 2 different.
Well, Exhibit A appears to be comments about police officers.
Yes, Your Honor.
And there's one comment about judges, and then there was one comment that appeared to be sexual. It doesn't seem to have any relevance to anything.
Mr. Loyd says he will not go back to prison. Is irrelevant to that statement. And that's the second half of the state's motion.
Okay, that's Exhibit B.
That's Exhibit B. That's correct.
That clarifies it somewhat.
Yes, Your Honor.
I couldn't find exhibit any other.
I agree that that motion does not support his intention to kill an officer and his motive to
Okay.
avoid arrest in this case.
So B is avoiding arrest.
Yes, Your Honor.
Okay. So just to make sure that Exhibit A, you're telling me the state wants to offer it in their case in chief to go to premeditation and motive.
Yes, Your Honor.
And Exhibit B, you want to offer in your case in chief as avoiding arrest and escape,
The motive. Yes, Your Honor.
or motive, okay. All right, thank you, Mr. Loyd. Anything else you wanted to add to your argument?
No, Your Honor.
Mr. Lenneman?
Yeah, Judge, in consideration, I think the court is required to review the evidence. I'd ask the court if they haven't, at this point, reviewed the video of the shooting. It is important because when Mr. Loyd breaks away from the unarmed, he's wanting to get away. Does not pull on the door, does not shoot at the door, penetrate the door. None of that happens. So I think that what you're throwing out there is clearly 403 based up to try to bootstrap facts that aren't there. There was a shootout that occurred, Judge. She has 8 or 9 casings around her. And although they're going to get up there and argue that he executed her, any person who watches that video can tell there's a shootout going on between the two. And obviously, our position is that she fired first. And that's what caused Mr. Loyd to draw his gun. And I think the video is consistent. So for them to bootstrap these things that are prejudicial and not relevant, they're doing it to inflame the jury. And that's all that it is.
Let me ask you a question. This one right here, that article, is that part of the stipulation that Mr. Loyd is the person who posted this?
I don't
It
know.
appears to be him posting it.
He commented.
So he's commenting on this article? Because there's a reference to the article. I didn't know if he posted it or commented on it. Okay. Were these all pulled off his Facebook page?
Yes, Your Honor.
So he would have had to post it to comment on it.
That's
Okay. All right, I'll take a look at these in detail, and we're going to get a ruling Monday, because we're going to need this for the guilt-based portion of this. When did you all get these Facebook posts?
We've had them for some time. It took some time to go through them. Judge, you asked if you would maybe ask if I had anything else. Mr. Buxman involved me that the remoteness issue, to the extent of attachment to any of the posts to go away and not miscibility. The other thing that I would note is that the argument that is being made is the very reason why these posts are necessary to comply with that. If Mr. Loyd, 6 months, told someone in person that people should rally to kill police officers, and then 6 months later murdered a police officer, I find it hard to believe a court where that would not be admissible. And Facebook has just given us insight into a person's mind.
Okay. I'm going to reserve on this one. I'll get you guys a ruling on it.
So
I just need to take a look at it. What?
So the court is aware of those five.
Is the state aware of which ones they are? Two are testifying in guilt or penalty.
That means guilty.
Yeah, I was going to say, so he's testifying as to the insanity defense. And they still don't have the Facebook post? And when are you getting them, the Facebook post?
My intent is to get them this weekend. So the court's aware there's 30,000 cases.
Well, you need to get it to them because we're coming up on trial, folks. This is all extremely late. All right. Any other motions that are pending that I haven't called up?
Not a motion, but an issue that has kind of come up that it gives me concern about guilt phase. We have a witness, the medical examiner that did Sade Dixon's autopsy, Dr. Zadovich. She is in Mexico next week, so I asked Mr. Lenneman if he would be willing to either stipulate to her testimony or allow her to appear by Zoom, because her testimony is going to consist of, in order to try to be consistent with the court's ruling and the parameters that we've discussed, All she's going to do is say, I performed an autopsy on Sade Dixon. During the autopsy, I removed a projectile from her body and introduced the projectile. That projectile was then tied to the firearm. I don't plan on having any discussion with her about any specific injuries, any photos, nothing more than what I just laid out to the court. My understanding is that the defense is planning on objecting to any mention of Sade Dixon's autopsy or the projectile, which in my mind is different than the parameters that we had discussed leading up to this trial.
Well, remind me what parameters. I've discussed so many parameters with you all. Which parameters are we talking about this time?
It was my understanding that basically the entire Sade Dixon incident was going to be coming into evidence, especially since we've now told the jury that Sade Dixon was murdered and a conviction was obtained.
Right.
So therefore, I don't think any evidence of the fact that an autopsy was done and a projectile was removed from her body violates any of that understanding.
So Sade Dixon's coming in. I know the defense wants to argue the weight of that one, and you said that in a prior hearing that you wanted to dispute. So it's penalty phase. So the projectile removed from Miss Dixon's body matches the gun and the projectile from
The Walmart shooting.
the Walmart shooting.
We did file the motion to admit that as Williams rule. That was denied. After your ruling on the Williams rule,
But then, you all appealed. Then you said it doesn't matter because I'm going to bring it all in anyway.
yes. So
what's
that
the
was.
prejudice?
I'm sorry.
I'm sorry. What's the prejudice to the defense?
All right, Judge. My client first wants to remind the court that you denied his motion. So in order for him to adequately address the entire Dixon issue, he would have needed right to dispute certain issues. Putting that aside, Judge, he has told me numerous times that this has nothing to do with money. Our intent in terms of the Dixon is very narrow, both my client's state of mind in regards to the issue of police issuing information that was not correct, and him reaching out to his police side, and she reached out to the police, and the police basically said, we can't do anything about the fact. I mean, that goes to his state of mind. That's really the narrow issue that it's not being offered for truth. It's being offered for the state of mind, which is continuous of his belief that the police are trying to kill him.
But so let me get this straight, because we had a lengthy hearing about this, where you informed the court that you all intended to introduce the Dixon case in the guilt phase of this case. After I had said, nobody can talk about this, the only thing you can talk about is he had an arrest warrant. Then you all had me read stipulated facts to the jury that say that Lieutenant Clayton was approaching Mr. Loyd about his involvement in the Dixon homicide. And now you're saying that you don't want them to introduce the fact that the gun that killed Sade Dixon was the same gun that was used in the killing of Lieutenant Clayton. State,
I just know
what's the purpose of introducing the bullet from Miss, just to get it on the record, what is the purpose of introducing the bullet that was removed from Miss Dixon? So I'm sure that I understand what you all are saying.
Yes, ma'am. It was fired from the .40 caliber firearm that was used to kill Debra Clayton as well. To prove the identity, he had an arrest warrant for that crime. That gun is tied to the Dixon crime and the Walmart crime. And our plan was to basically call Andrew Harrison, who was the crime scene investigator who processed the Dixon scene,
Okay.
solely to say, I arrived there, I collected 11 shell casings. That's it, because those shell casings were also fired from the same gun.
Okay.
Call Dr. Zadovich to say, I performed an autopsy on Sade Dixon. I removed a projectile, introduced that projectile. And then obviously it would be tied up with Richard Ruth, who was the firearms analyst from FDLE, who said all these things were fired from the gun used to kill Lieutenant Clayton.
So they're establishing through that evidence, Judge, that Mike fired 11 shots. For what purpose is not the general conviction we agree to that.
Well, the 11 shots were fired at the scene of Lieutenant Clayton's death, which is
11 shots fired at
at
11
Dixon.
shell casings fired from the defendant's force.
Oh, you're talking about Dixon's 11 shell
Yes.
casings.
And the last I heard, this was all going to be admissible, and I just want to know what rules we're playing by so we don't run afoul.
So do I, because the last I was told it was all admissible because you all wanted it all in, and the state was going to, Mr. Loyd, not now, and the state was not going to, no, you were not. We'll get to you in a minute, Mr. Loyd. So you told me and told them that all of this was coming in guilt phase after I said none of it was coming in. Then we read a statement to the jury, and now we're going to go backwards again?
I don't think I said all, I said some. Some of it's coming.
Actually, you said almost everything, because I tried to get you to narrow it for me, and you told me almost all of it was going to, you wanted it. The phrase was I just want to talk about all of it, is what you said. And then you said there might be one or two things, like you told me you didn't want to get into 2 guns versus 1. And so now you're telling me you don't want to get into anything other than there was an arrest warrant. And there's no way I'm going to tell the state they can't talk about it was an arrest warrant for the homicide of Miss Dixon, since we just read a statement to every juror.
One has a problem with the number of bullets, in fact, that they were shot from the same gun as Clayton. We already knew from footage that was
In the guilt phase. So I don't think we need to talk about the 11 shell casings in the guilt phase. However, if you all start talking about all this stuff, it's all coming in, all right? Enough already. So you can put in that the bullet that was removed from her matches the gun that was used in Clayton, because it all ties to why Lieutenant Clayton was attempting to arrest him and to the arrest warrant and to the whole scene that was going on. So I have no issue with the medical examiner testifying that there is a bullet removed from Sade Dixon that matches the gun that was used in the shooting of Lieutenant Clayton.
Okay.
I don't know why you need to tell them that there's 11 in the guilt phase. We'll see how far it goes in the penalty phase. The circumstances surrounding the shooting are may or may not be admissible.
Okay. To the original issue that brought this up, Dr. Zadovich is going to be in Mexico. I'm requesting to allow her to testify by Zoom for that very limited piece of information.
That is true, that is what we were talking about when this all started. Do you have an objection to her testifying by Zoom? To say that the bullet that was removed from Ms. Dixon matches the gun that she removed a bullet, and then eventually the forensic expert's going to say it matches the bullets, it matches the gun that shot Lieutenant Clayton. Do you object to her testifying by Zoom is the question. All right, so I've overruled your objection to her testifying. What? You need to stand when addressing the court.
in a position when my client is substantially assisted in his representation. And so there are certain things that I believe I have to agree to request. One of them is that he does not want me to
He does not want you to agree to what? I'm sorry. Okay, that, I understand that you are not agreeing to it. I don't see any prejudice to you all to her testifying. You have her previous trial testimony. Her testimony is, she's also more than 100 miles outside the jurisdiction of the court at this point, since she's going to be in Mexico. All she's testifying to is a bullet that was removed from Ms. Dixon. State?
That's it, Your Honor. That's all she's testifying.
All right, so the motion to have her testify by Zoom is granted. Don't bring up the 11 shell cases in the guilt phase, okay? Anything else I needed to rule on? Because this is just wandering.
I don't know Dominique Daniels. I'll defer to Mr. Williams on that one since.
All right, who's Dominique Daniels, remind me?
Miss Dixon's younger brother.
Okay.
So it,
Not the one that was shot,
correct,
the one that was inside the house.
correct.
Okay, go ahead.
Based upon the prior understanding, the state's intention was to call Mr. Daniels to say that he encountered, if you recall his trial testimony from the first trial, he encountered Mr. Loyd outside, he heard gunshots, he ran to the door, he saw Mr. Loyd fleeing. If we're not going to be permitted to do that, I certainly need to know that before I stand up and opening statements. But it is not the brother that was shot, it is the brother that witnessed Mr. Loyd in the yard and then
Right.
flight from the yard.
Well, based on what I'm being told today, that's not going to be brought up by the defense during guilt phase. Is that correct? All right, tell me exactly, so because the state has to know what they can and can't say in closings or in openings. And quite frankly, this has changed several times. I want to know exactly what you are going to say about Miss Dixon's murder in the guilt phase of this trial.
One reason is that there was a gun found in the yard.
In what yard?
The yard in the shooting.
Okay, go ahead. Let me listen to all this.
And then when my client found out that they were publishing reports, that he intentionally went up to the door and shot her and pulled blood, he reached out to his niece, who reached out to Savelli and told them basically that, what's going on with these lies, why are you publishing this? Savelli basically says that he can't control what they do. And so my client, of course, had mentioned that he was willing to turn himself in if they did that, if they corrected the wrong. And when they are not correcting the wrong, my client is reaching a heightened state regarding his belief that the police really killed him. So he believes that this was all done intentionally so the police could kill him. And that's important to the state of mind of my client. As it continues through, and we'll have evidence that occurred before as well.
State.
So if I understand it correctly, the defense wants to bring out specifics of what was located at the Long Peak Drive Dixon scene, specifically the gun, and portray that a false narrative was portrayed or was released, but the state is unable to fix that false narrative and unable to bring in the fact that there were 11 shell casings on scene. I mean,
No, I'm not going to allow that. That's where we're at halt. If you want to argue that a gun belonging to Miss Dixon was found in the yard and that the police were putting out a false narrative that it was Mr. Loyd who was the aggressor in that, and I'm paraphrasing this, okay? Then the state gets to rebut that in guilt.
We have absolute proof because we have the three
Mr. Letterman, I'm not going to argue whether you have proof or don't have proof, but what you can't do is stand up in openings and say all this stuff with the state being handicapped, unable to respond. So the state can respond to them saying there's a gun in the yard and that it's a false narrative that Mr. Loyd was the aggressor. Okay?
Does that include the state being able to respond that 11 shell casings were found at the scene?
Yes.
Thank you.
That belong to the gun, because that goes directly to the issue of whether the narrative was false or not.
Thank you.
Yes. And I'm done with this. All right. Are we done with the motions?
I believe so.
All right, Mr. Loyd, go ahead.
I want to put this on record. What I told my attorney, what I wanted to present from the Dixon case was the lie that was told to the news, that I came over here, bammed on the door, and gunned these people down. That was completely lie. You was the judge in the trial. So you know that's a lie. That was a complete lie. I reached out to my niece, and I told my niece that this didn't happen like that. This girl put a gun on me, her brother attacked me. I said, talk to the investigator, which I talked to Bella, whoever, or Pegan. He said during the investigation, during the interrogation. And I told him I would turn myself in if they get the news to retract a lie that they done told the whole world. Why are they lying? They trying to kill me. And they told my niece they are not responsible for what the news play. But come to find out, it's reports that they are responsible for what the news play. So now, when I find that out, now I know it's the police that's setting me up and trying to kill me. At first, I thought Sade's mom and them removed the gun and stuff off the crime scene that Sade went and got when it got on me. So now I know it's the police that set me up, because if I'm an investigator and I had this alleged murderer telling me he would turn himself in if I retract a lie at the news play and I know it's a lie, I would hold a press conference and retract the lie that had this alleged murderer turn himself in. But they told my niece, which told me they had. But excuse me, I'm gonna get up.
You need to calm down.
No, cause I got to stutter. I stutter anyway. In this.
Just calm down and tell me calmly what it is you want to tell me.
So,
Mr. Loyd, you are being allowed to present that to the jury. The
no, but
conversation that we are having is not about you presenting that to the jury, but what the state can say in response to that.
So now, back to what I said. The only thing what I wanted my attorney, what I told them, was the news reported I came over here, bammed on these people's door, and gunned these people down when they answered it. And that's a complete lie. Everyone seen my trial. And the investigator knew it was a lie, but they the ones reported this lie so they can put their framework in play to kill me when they run down on me. And I talked to them through my niece, and I told them, I believe y'all are trying to kill me. Why are y'all lying? What you lying for? They kill us for nothing. They kill us with our hands up. So now you put out this false narrative. So now the public, when you run down on me and kill me, it won't be no uproar in the community, because they done created this monster which never existed. So now I'm telling my niece to tell her I will turn myself in, but they tell my niece they're not responsible for the news play. So now I know it's them that's doing it. So now I send my niece to the news people. I say, go talk to the news people. Talk to them. I'm like, man, y'all got to talk. Somebody got to say something. I send my niece to the news people, and she tell the news people whatever she tell them, and then they have this interview or whatever, and I call them, I'm like, what's happening? What's going on? She started crying, and she hysterical. She's like, Uncle Keith, they play what they want to play. They play what they want to play. I'm like, man, fuck it. These crackers trying to kill me. So now I'm laying low. So now I'm out. I'm trying to get my people to talk, but everybody's scared to say anything. I was trying to. Walmart never had to happen. But these are the same investigators. These are the same investigators that were setting my niece up, setting my ex up, setting my family. These are the same ones that say they're not responsible for the news play. These are the same ones that lied to me, and that's why they want to exclude these investigators right here from us from saying anything, because they are a bunch of liars, and it's been proven. In my first trial, it's been proven. They lied on my niece. They lied on my ex. They was lying on me. And they the ones set this lie about. Walmart never had to happen. So they trying to evade it. No, I was trying to turn myself in twice before Walmart. And even after Walmart, the third time, I was turning myself in. These clowns didn't find me. I was turning myself in on the phone call, talking to my people, trying to turn myself in, because they were setting my ex up, which has a mental disability, and I know how the system works. They were drag her in these courtrooms and give her a life sentence for something she had nothing to do. And so before I let her do that, I'll die. So I came, and I still, when I was turning myself in, when they came to the house, even when I came to the door, I got low. So now I was telling them to get these other investigators, but they haven't done yet either. When I was turning myself in, when they came to the house, I got low. I got small. So they start opening fire on me.
Calm down, Mr. Loyd. Take a deep breath.
My belief of them not trying to kill me, it didn't go away. But for my people, I die. I don't care. I will die for my people. So I'm not gonna not let my ex or my people come here and do no life sentence for nothing they had nothing to do with. So that's why I came back. For my people, I die about my people. It ain't about, I'm trying to kill cops. That's a fucking lie. But when cops killing us, I speak out. I'm not doing none of that.
All right. I've got it, Mr. Loyd. All right, thank you very much. Everyone has my rulings. I have a reserved ruling on the Facebook motion. What was the other one I reserved on? I made a note.
Use of force.
The use of, the rehearing on the use of force. I'll take care of those in chambers. Is there anything else, Mr.?
Mr. Loyd said on the record a few moments ago he wanted to represent himself. It's the state's position that you really need to address that.
Oh, yeah, he did. Thanks. Mr. Loyd, do you, well, first of all, I'm not doing a Nelson hearing because the trial has begun. There's a jury's venire has been sworn. So, Mr. Loyd, do you want to represent yourself? Or you want to keep your lawyers?
Yes, I want to represent myself.
So you want to fire your 2 lawyers?
No, I want to be first chair, second chair, how I had it for last time. And since Terry know everything, I got to keep Terry.
Okay. And what is the reason that you want to represent yourself?
Because things are being done and it's not being done right, and my life is on the line. They're just like, even with the situation, and I told them I only want the fact for my mind, it was my mind state that the police was trying to kill me. They reported I came over here to my child's mother's house, banged on the door, and gunned these people down. That never happened. Everyone's seen my trial, so y'all know a fact.
Mr. Loyd, focus on what we're talking about. So you don't like the rulings that the court is making, or you don't like?
I don't like the ruling the court making and the arguments and the stuff that's being put forth on this side, because it's not. I'm upset right now. I can't even talk good right now, and I can't talk no more. I'm upset.
Okay. Anything else about representing yourself? Mr. Lenneman, would you or Mr. Marrero care to put anything on the record as to that? All right. Mr. Loyd, we've been down this road before. You asked to represent yourself. I granted your motion. You struggled. You then asked me to appoint Mr. Marrero as co-counsel. As I've repeatedly explained to you, you are not an attorney. You are not lead counsel. I did that. I appointed Mr. Marrero as co-counsel. You then told me that you could not represent yourself because of the restrictions that you have, because you are an inmate and you were unable to effectively represent yourself, and therefore asked me to reappoint Mr. Lenneman as your attorneys, and I did that. The case law is clear that while defendants have the right to represent themselves, they do not have the right to go back and forth. You can't decide that you want to represent yourself, then you don't want to represent yourself, then you want to have an attorney, then you don't want to have an attorney, then you want to have co-counsel. The court has observed and acknowledges the following, which is that, quite frankly, sir, you are an inmate. You were unable to effectively represent yourself the first time I granted it, and nothing has changed at all in your situation. The motion to proceed pro se is denied. You continue to have lawyers, and you continue to be allowed, as you have been throughout these proceedings, to actively participate in your defense. The court has given you the opportunity to speak when you've wanted to. I have observed, as has everyone in the courtroom, that your attorneys take direction from you. When you want something done, they stop and they do it. So the motion to represent yourself is denied. We are here on Monday morning, courtroom 23, for jury selection. Anything further from state?
Nothing, they can't wait till Monday.
Is there something you want to talk about now?
Your Honor, I fail to see how, there's 2 issues. Number one, it is very unclear to me, and I'll be doing the opening statement, what I can say and not say, but I will do my best to deal with that over the weekend and address it on Monday. The second thing is, I know we've been talking about what defense counsel plans to present, but I'm uncomfortable with defense counsel discussing any of what Mr. Loyd just discussed in opening statements, because I don't see how it's relevant or admissible. So while it may become relevant or admissible during the trial, and I don't want to object in front of the jury during opening statements. It's not my style to do that and interrupt. So I would like to know again, and I know it's difficult for Your Honor because the sands are shifting for all of us, but I would prefer to not have to object during Mr. Lenneman's opening when he's going to testify to something that may or may not be admissible at all.
And while I understand the position you're in, the court is also in a position that is a bit my hands are a bit tied in that the defense has the right to present their defense during the guilt phase. The court cannot interfere with that so long as they're not trying to do something that's completely inadmissible. The defense's the defense in this case has some fluidity to it. Let me phrase it that way. And that the court is not completely certain exactly what witnesses are going to say or exactly what the